Good afternoon, honorable members. I welcome all the members who have logged into the virtual mini plenary session. We will now have an opportunity for silent prayer or meditation. Thank you, honorable members. Honorable members, before we proceed, I would like to remind you that the virtual mini plenary is deemed to be in the precinct of Parliament and constitute a meeting of the National Assembly for the debating purposes only. In addition to the rules of the virtual sittings, the rules of the National Assembly, including the rules of debate, apply. Members enjoy the same powers and privileges that apply in a sitting of the National Assembly. Members should equally note that anything that is said in the virtual platform is deemed to have been said to the House and may be ruled upon. All members who have logged in shall be considered to be present and are requested to mute their microphones and only unmute when recognized to speak. This is because the mics are very sensitive and will pick up noise which might disturb the attention of other members. When recognized to speak, unmute your microphone and connect your video. Members may make use of the icons on the bar at the bottom of their screens, which has an option that allows for a member to put up his hand to raise points of order. The Secretariat will assist in alerting the chairperson to members requesting to speak. When using this virtual system, members are urged to refrain and desist from unnecessary points of order or interjections. Honorable members, we shall now proceed to the order, which is a debate on vote 27, Office of the Chief Justice Appropriation Bill. Having said so, I wish to welcome the Honorable Minister of Justice and Correctional Services, Tatana Lamula. You are welcome.
I am so much truly Arkansas ministers and deputy ministers on the platform, honorable members, distinguished members of the judiciary, heads of professional law bodies, distinguished guests, ladies and gentlemen. Today, I wish to table the budget of the National Department of the Office of the Chief Justice. The budget consists of 1.211 billion for voted funds and a further 1.118 billion for judges' remuneration, which is a direct charge to the National Revenue Fund.
Honorable Minister,
judicial education.
Honorable Minister, my apologies to disturb you. I see Mr. Swart's hand is up. Maybe he's going to talk about also what I wanted to talk about, but let me allow him first. Honorable Swart.
Indeed, House Chair, that minister is a shadow of his former self, and we'd like to see more clearly. I'm sure that's the issue you wanted to raise as well.
Yes.
Thank you, House Chair.
Thank you. No, it is true. Minister, I don't know what's happening with your background is bright, but you are just a dark figure that we can't even see. I'm not sure what's happening where you are. Maybe you may be assisted. Oh, so you're gonna go without the video. There's no problem, but they can help you to, you are very dark. But if you want to proceed without the video, you also allowed to do so. Is the minister still there? Table.
Yeah, Chairperson, I'm here. On my side, I can't see how the picture looks like, but we've tried to remove and put some lights. I don't know if that will help, if it is helping.
No, it's not. You know, the background is so bright, but where you are, it's very, very dark. And, you know, you respect.
We'll just switch off the.
So I don't know. Continue. Oh, Mr. Changi.
Yes, Honorable Chair, I was going to ask that he continues because we can hear him
Yes.
quite clear. He's very clear.
Yes.
We know him is dark, so if we don't see him,
No. It's not about that. Don't be out of order, Honorable Changi. Okay, continue, Honorable Minister. We can hear you very clearly. It is only the lighting there where you are. Thank you. Proceed.
Thank you,
You may
Chairperson.
start. Yes.
Yeah, thank you, Chairperson. Today, I wish to table the budget of the National Department of the Office of the Chief Justice. The budget consists of a 1.211 billion for voted funds and a further 1.118 billion for judges' remuneration, which is a direct charge to the National Revenue Fund. The superior courts and the judicial education support are allocated 81.14% of the total budget. A budget reduction of 30 million rands on goods and services and payment for capital assets was already implemented on the operational budget during the special COVID-19 adjusted budget. This reduction represents 8.8% of the department's goods and services budget, much of which is deployed towards court operations. Honorable members, even though budgets across governments have contracted and resources have been redirected to respond to the national COVID-19 emergency, we have to be innovative and develop new ways of operating in order for us to keep the courts operational under the new normal. Children born of the same family, they share the head of a locust, honorable members. And this is what is happening across all government departments, and the Office of the Chief Justice is no exception. We have to do with what is available. During this period of COVID-19, the department has reprioritized its budget and operations in order to ensure that the delivery of core services, that is the support to the courts, is not negatively affected. This, however, has increased operational pressures in the courts and has necessitated a dynamic approach when implementing the mandate. In the current medium-term expenditure framework budget, the compensation of employees' budget of the department was reduced by 263.69 million, 14.9%, and the budget of judges' salaries was reduced by 334,238, which is 14.6%. The operational budget has experienced further reductions of 32,742,000, representing a further reduction of 3.4%. In spite of these difficult economic and public health complications, we are more than determined to serve our nation and deliver strongly on constitutional promise. This year, our nation celebrates the 25th anniversary of the Constitution of the Republic of South Africa. The first democratically elected Constitutional Assembly adopted this constitution in 1994 in this House. The adoption of the Constitution was one of the most critical milestones reached by our beautiful country, and we will cherish it forever. During the adoption of this revered Constitution on 8 May 1996, President Cyril Ramaphosa, in his capacity as the chairperson of the Constitutional Assembly, as he was then, made the following defining observation, and I quote, "This Constitution with its Bill of Rights is the mirror of the South African society. It reflects both the history from which we have emerged and the values we now cherish: human dignity, equality, and freedom. It proclaims to the world that we are a society committed to democracy, to the rule of law, and to the protection of human rights. It proclaims to all South Africans, the landless, the homeless, the women, the workers, and the children of this country, that their basic needs and aspirations matter enough to be included in the country's constitution." He went further to state that through this constitution, we hope to transform our society from one that is based on injustice and strive to one based on justice and peace. Close quote. Honorable members, the celebration of the Constitution with its commitment to the rule of law and the protection of human rights will be insufficient if we do not celebrate our country's strong and independent judiciary, which delivers justice impartially and without fear, favor, or prejudice. The judiciary are without a doubt the guardians of our Constitution. Our judiciary is central to ensuring that the constitutional vision of transformative society is fulfilled. The Constitution vests judicial authority in the courts and guarantees their independence. It also compels organs of state through the necessary means to assist and protect the courts, to ensure their independence, impartiality, dignity, accessibility, and effectiveness. The Office of the Chief Justice, the OCJ, is one of the measures the state has put in place to support our judiciary in discharging its responsibility. Judicial independence, which is foundational to and indispensable for the discharge of our judicial function in a constitutional democracy based on a rule of law. This independency, of which structural independence is indispensable part, is expressly proclaimed and protected and promoted by subsection 2, 3, and 4 of section 165 of the Constitution. This was said by the Constitutional Court by Justice Ackerman in the DeLange versus Smart matter. In line with section 165, subsection 4 of the Constitution, the OCJ has continued to provide support to the judiciary to ensure effective and efficient court administration services despite the difficult conditions. This has been made possible by the Chief Justice directives and the various measures put in place by government in response to COVID-19 pandemic. The introduction of these measures has ensured that the courts and the public service, including the OCJ, remained functional during this challenging period, whilst also ensuring the safety of both court users and officials. Honorable members, the OCJ continues to contribute to Chapter 14 of the National Development Plan, priority of strengthening judicial governance and the rule of law, by providing training to the judges and aspirant judges through the South African Judicial Education Institute. Mindful of its critical role to the country's priority and the importance of scaling up judicial, Sanjay has put in place measures to mitigate the impact of COVID-19 on Sanjay operations. The Sanjay introduced online training platform through the use of MS Teams and Zoom. In addition, Sanjay has introduced a Sanjay online portal for the easy access to training material by judicial officers. Ad hoc training programs resulting from requests from the leadership of the judiciary based on the identified needs have been implemented, and as a result, 123 judicial education courses for judicial officers were conducted during the period under review, and the courses were attended by 3,297 delegates. In line with the objectives of Sanjay Act 14 of 2008, The Institute will be working on programs specifically for aspiring women judges in order to contribute towards transformational judicial education and training. In his State of the Nation address of 11 February 2021, President Cyril Ramaphosa reiterated government commitment to fighting corruption and strengthening the state. The diagnostic report on the NDP on corruption observed that South Africa suffers from high levels of corruption that undermines the rule of law and hinder development and socio-economic transformation. This observation still finds relevance today and points to the need for a strong and independent judiciary that will adjudicate without fear or favor on matters related to corruption. Honorable members, part of the work of the Office of the OCJ is providing secretarial support to the Judicial Service Commission. The JSC. Among other responsibilities, the JSC Secretariat coordinates the JSC sittings. Members will remember that during the previous phase in April and October 2020, were postponed to the current financial year due to COVID-19 lockdown restrictions. The OCJ, through the JSC Secretariat, recently organized an extended hybrid sitting, a physical and a virtual sitting, on which candidates for the vacant judicial positions in various superior courts were interviewed. The support provided to the JSC in this regard has ensured that it keeps in step with its mandate to ensure judicial vacancies in the courts are filled by competent judicial officers that also contribute to the transformation agenda of the judiciary. The appointment is en route to the President to effect the appointments of the last Judicial Service Commission sitting. Honorable Chairperson, the modernization of the courts and the digital transformation remain crucial for improving service delivery. The COVID-19 pandemic has necessitated that the OCJ moves with speed to leverage digital platforms and make digital transformation a reality in the courts. The OCJ has partially implemented the court online system in the Gauteng division of the High Court. Caseline, as a standalone solution for evidence management, was successfully piloted at this court in this division. The court online system is an advanced cloud-based collaboration that is aimed at providing a platform to legal practitioners or litigants to file documents to the courts electronically, e-filing over the internet. The OCJ aims to continue the rollout of this electronic platform to other service centers during the medium-term strategic framework period in order to contribute to the government's goal of broadening access to justice. Honorable members, the importance of the judiciary cannot be overemphasized if our democracy is to continue to flourish. It's the judiciary that ensures our celebrated constitution is upheld and protected. Allow me to close with a quote from former Chief Justice Arthur Chaskalson when he addressed the Cape Law Society in 2012 on the importance of an independent judiciary. He said, and I quote, "The supremacy of the Constitution and the rule of law requires everybody in our country, including Parliament and the executive, to obey the law and to respect and uphold the provisions of the Constitution. Our Constitution is explicit about these obligations, and courts are mandated to be the guardian of the Constitution. This is the role of our courts in a constitutional democracy. This is in line with modern democratic theory, which recognize that respect for fundamental rights and the rule of law are essential components of a democratic system of government." Close quote. For our part as the executive, we're doing all we can through the OCJ and other avenues to support and promote a robust judiciary that delivers with aplomb on the constitutional promise for an uncompromising rule of law. We call on this House to stand with us on this mission. Chairperson and honorable members, I therefore present the 2020-2021 budget vote 27 of the Office of the Chief Justice for your support and approval. As I step off the podium, allow me to convey our profound gratitude to the Chairperson of the Portfolio Committee and his entire committee for their continued support and guidance. Allow me to extend a word of appreciation to the Chief Justice of the Republic of South Africa, Chief Justice Mogoeng as he retires in October 2021 for his astute leadership of the judiciary and wish him well for the future. We hope Parliament will accede to the request we have made with regards to this end of term of the Chief Justice. I acknowledge Acting Chief Justice Raymond Zondo for the work he continued to do as the chairperson of the Judicial Commission of Inquiry into allegations of state capture. May I also recognize the Acting Deputy Chief Justice Sisika Pembe, President of the Supreme Court of Appeal, Justice Mandi Samaya, the heads of courts, and the chairperson of the Magistrates Commission, Deputy Judge President Lidwaba, all members of our judiciary for their continued services to the people of South Africa. The oversight role played by the OCJ Audit and Risk Committee should also be acknowledged. Lastly, but not least, I thank the Secretary General of the Office of the Chief Justice, Ms. Meme Sijasongwe, the management team of the OCJ, and the staff for their tireless efforts in serving the people of South Africa. Thank you very much.
We proceed, and I will call on the chairperson of the Portfolio Committee, Honorable Magwanishe, to proceed with the debate.
Honorable Chairperson, honorable members, let me start by also agreeing with the Minister to wish our Chief Justice well into his retirement. The functioning justice system is one of the glues that keep society together. Its integrity must be beyond reproach. Therefore, the committee believes that the decision to implement budget cuts should be fit for purpose. In the case of the Office of the Chief Justice, it should not be forgotten that the rule of law supports healthy economies and allows people to feel safe. As the Office of the Chief Justice is labor intensive, the cut to the salaries budget is likely to negatively affect the delivery of court services, compromising the right of users of our courts to access to justice. Also, the cuts may undermine the judicial function. This failure to adequately resource the judiciary could be regarded as undermining judicial independence. The committee is concerned that the case backlogs may eventually overwhelm the legal system, undermine the right of access to justice. Although there is a plan to address the backlogs, warm bodies are needed for this. Given the cuts to salaries, the committee is unclear how it will be possible to realize the plan, but will continue to monitor the situation closely. The COVID-19 pandemic has provided increased impetus to the court modernization projects that will result in a more effective and efficient court system. The ICT 5-year strategic plan provides the technology roadmap to automate, digitize, and transform the delivery of services, but the committee is extremely concerned that a lack of funds may undermine the rollout of these important modernization projects. The committee trusts that the Office of the Chief Justice will not be required to fund the land court from its existing budget baseline. The committee will engage further on the resourcing of the court when it considers the land court bill. Although the Office of the Chief Justice did not achieve the representation targets of 50% females at SMS level and 2% for people with disabilities, the committee welcomes the commitment to reaching these targets by making use of various targeted strategies. Again, the committee will continue to monitor progress regularly. The committee wishes to thank the Office of the Chief Justice for facilitating the meeting between it and the judiciary. The committee undertook to engage with the minister on a number of matters discussed and will arrange a meeting as soon as its program permits. The committee, having considered the Office of the Chief Justice Annual Performance Plan 2021-2022, supports these and recommends that the National Assembly approves them. The committee, having considered Budget Vote 27, Office of the Chief Justice and Judicial Administration, supports the vote and recommends that it be approved. I thank you, Chairperson.
Thank you, Baba Makwanisha. Siyaqhuba. We go to the DA, Honorable Breitenbach.
Thank you, Honourable House Chair, honourable members. The Office of the Chief Justice and Judicial Administration was allocated its first budget vote as from the 1st of April 2015. The transfer of administrative functions and identified staff attached to the Superior Courts from the Justice Department to the OCJ commenced in October 2014. The department has continued to support the administration of the Magistrates' Courts. Significant gains have been achieved by this office, and the management of its budget continues to be well received by the Auditor General. In dealing with the COVID pandemic, some notable successes were achieved, but the growing backlog in the court rolls cannot be ignored, as is the case with dwindling court hours. Significantly, the Constitution's 17th Amendment Act designated the Chief Justice as head of the judiciary, with responsibility over the establishment and monitoring of norms and standards for the exercise of judicial functions of all courts. This responsibility includes presiding over the Judicial Services Commission, responsible for appointing judges and safeguarding the integrity of the judiciary. And unfortunately, in the current prevailing circumstances, a discussion on judicial integrity is unavoidable, despite the fact that our judiciary has been a shining light in difficult times and has justifiably earned the respect of most South Africans. Explosive allegations of corruption were made in February at the Zondo Commission of Inquiry by acting SSA Director General Loyiso Jafta, who told Deputy Chief Justice Raymond Zondo that while allegations have not been levelled at a particular judge, bribes were allegedly paid in order to influence judges in favour of President Zuma. Our Constitution provides that the courts are independent and subject only to the Constitution and the law, which must be applied impartially and without fear, favour or prejudice. The Bangalore Principles, which provide the international best practice standard for judicial conduct, require that judges exercise their functions free of any extraneous influences, inducements, pressures, threats, or interference. It is surely impossible for a judge to act consistent with these requirements if they have received money from the SSA. These allegations turn an unwelcome spotlight onto the possibility of corruption in the judiciary. There has never been any definite evidence of corruption by judges, but the allegations made at the Commission will be harmful for public confidence in the judiciary. The evidence of Sydney Mufamadi concerning the so-called Project Justice, allegedly aimed at paying millions of rands to members of the judiciary, has not helped this perception. And the most recent evidence of millions of rands in cash being handed to David Mahlobo for onward passage to members of the judiciary have underlined this very serious potential risk. Unfortunately, the process of the JSC in this regard are noted only for their glacial pace, taking 20 years to deal with the Mutata matter and over 12 years to deal with Judge President Hlophe, and that matter is far from over. Any allegation of this serious nature must be investigated, but it is not ideal to involve judges in this investigation, as the appearance of the judiciary investigating itself will not inspire confidence. The process of a judicial commission of inquiry appears to be the most appropriate course of action, with serious consequences in the form of prosecutions by the NPA should the findings warrant it. An independent commission headed by credible legal professionals that could include a retired judge is urgent and necessary to ensure that the judiciary is not permanently stained by the allegations that have been made. In demonstrating that the JSC is capable of acting against judges when their conduct falls short of the mark, the JSC announced 2 recommendations for suspension for complaints of gross misconduct some time ago. It has been recommended that President Ramaphosa suspends Judge Parker and Judge Makabela, pending the outcome of their hearings by the Judicial Conduct Tribunal. If they are suspended, they will be the first suspensions on gross misconduct claim in South Africa's history since 1994. While the conduct of both is serious and falls woefully short of the conduct expected from judges, neither can hold a candle to the conduct of Western Cape High Court Judge President John Hlophe when it comes to seriously egregious conduct. Hlophe has most recently accused the judiciary of being soaked in politics, battling to deal with transformation and allowing apartheid-era judges to dominate the narrative, tellingly after he had been found guilty of gross misconduct by the JSCT. One suspects that his disenchantment with South Africa's system of law arises instead from the fact that after 14 years of serious complaints, the legal system has finally found him guilty of gross misconduct. Recently, the Judicial Conduct Tribunal found that Hlophe had attempted to improperly influence Justice Besan Kabinde and Justice Chris Jafta in a pending case before the court at the time regarding Jacob Zuma. The tribunal ruled that Shlope, in a classic example of a judge soaked in politics, has breached Section 165 of the Constitution in that he attempted to improperly influence the two justices of the Constitutional Court to violate their oaths of office. The truly remarkable aspect of Judge Shlope's case is that despite the tribunal's findings, the Judicial Services Commission, supposedly the guardian of integrity of the South African judicial system, has consistently refused to recommend his suspension and also permitted him to participate in its deliberations on the appointment of judges in the Western Cape High Court. That Judge President Shlope has allocated to himself the public protector's challenge to the constitutionality of an inquiry into her fitness to hold office is evidence of his nonchalance in the face of a judicial crisis. And until these very pressing issues are resolved, a dark cloud will continue to hover over the judiciary and the public's perception thereof. The Chief Justice has now embarked on a well-earned sabbatical and will not return to office prior to his vacating office when his term ends in October. Whoever is chosen to fill that position will have to take cognizance of these important issues and deal with them as quickly as is possible, or the office of the Chief Justice will invariably continue to suffer from a serious perceived lack of credibility. I thank you.
Thank you, Honorable Breitenbach. From the EFF, let's recognize the Honorable Yako.
Enkosi kakhulu, Chairperson. Chairperson, when all else fails in a society such as ours, when the fissures that separate us widen, it is the judiciary that must stay unbending in its commitment to the truth and to justice. When a time comes in which society questions, sometimes vociferously, our society's organizing philosophy, which has sustained and perpetuated the colonial and apartheid legacy of oppression and exploitation, the judiciary must refuse to be used as an instrument of class exploitation and race oppression. The time has arrived in South Africa, and the Office of the Chief of Justice ought to stand head and shoulders above everyone else and reject all attempts to capture their judiciary. The courts are the last line of defense for the people of this country who face a bleak future because of leaders who have no interest in the development of this country, but who are obsessed with making money for themselves and their families. When the people of the country rise up to challenge these despotic and corrupt tendencies, the courts must never seek to close rank with the rich and powerful at the expense of the truth. There are worrying signs that our judiciary is fast getting absorbed in attempts to pervert the Constitution for nefarious reasons. The judgments of the court seem to have eyes and ears. They seem to have preferences. That is why now it's okay for judges to seal documents that may reveal corrupt dealings of those in power, and we are required to be okay with that. Today, it is okay for judges to change their jurisprudence when it comes to the powers and actions of the public protector. When the previous public protector railed, rightfully so, against the corrupt elements of the Zuma administration, the courts were only too eager to affirm her powers. When the current public protector goes, rightfully so, for the corrupt and destabilizing elements in the Ramaphosa administration, she gets slapped with a frivolous personal cost order for simply doing her job. The judiciary must do serious introspection about the role it plays in society and whether this role enhances its stature among the people. That said, we are very supportive of the role played by the Office of the Chief Justice and would like to see this office deepening its functions, particularly on areas relating to the training of judges. Further, we applaud the work done by the Office of the Chief Justice. We're not quite pleased with the time it takes to fill some of the vacancies, though, in our courts, the Constitutional Court included. To preserve jurisprudential coherence, the Constitutional Court must have all the judges of the Constitutional Court appointed permanently, and where vacancies occur, it must never take more than a year to fill those vacancies. For this reason, we must introduce measures to strengthen the Judicial Services Commission to ensure the adequate and speedy filling of judicial vacancies, the training of judges, and the qualitative transformation of the judiciary beyond numbers and demographics. We are pleased with the recent round of JC interviews and the recommendations that the JC has made for appointments to various courts around the country. We have also emphatically asked the Office of the Chief Justice to be more hands-on in the supervision of the lower courts too, particularly the magistrates' courts. It is at the level of the lower courts that most injustices happen, where accused people are kept in jail for years without trial, and where magistrates sometimes act with impunity in cohorts with corrupt local government officials. This supervision of the lower courts must essentially include making sure that working conditions at these courts are improved. The Lusikisiki Magistrate Court, for instance, is a container with no air conditioning and no equipment for recording in the court. You cannot expect justice when the magistrates and the prosecutors are working in conditions such as those. To this end, perhaps it is the right time to speak about whether the appointment of magistrates should not be done in the same way as that of judges in order to guarantee lifetime security to magistrates the same way it is done for judges. So to conclude, since this is the last budget vote debate with the Chief Justice Mogoeng as the Chief Justice of the Constitutional Court, we would like to thank Justice Mogoeng for the role he has played over the last couple of years. We thank him for his bravery, for his clarity of mind, and his refusal to be captured by the dominant faction in society. As you're planning your retirement in October this year, do so with the full confidence that many of us do appreciate you. So the EFF does support this budget vote. Thank you.
Thank you, Ms. Yako. We now proceed to the IFP Professor Msima.
Thank you, Honorable House Chair. Honorable members, the critical role of the Office of the Chief Justice in our democracy cannot be overstated. This critical role is this critical role is this is why the baseline reduction in funds allocated to the OCJ is concerning, as it will negatively affect its capacity to sufficiently resource courts in terms of personnel, equipment, and IC infrastructure. Further, the reduction compromises judicial functions, the court modernization process, and the constitutional right to access justice by reducing the number of circuit courts, among other necessary functions. The IFP notes with disappointment the developments at the Mpumalanga High Court, over and above the expense and the lengthy time period it took to complete and open the court. It is now apparent that the court continues to be a financial problem. Only 4 of the intended 8 courts were built at double the price with structural defects. The funds to remedy these structural defects will affect service delivery, both at that court and at others. The IFP wishes to caution government departments when engaging with service providers who inflate their prices. It is concerning that the OCJ, the buttress of our constitution, was not did not consider this more fully. The IFP is also concerned about the impact of the budget cuts on the establishment and functioning of the new land court. The Portfolio Committee on Justice was advised that one of the more pressing issues at the OCJ is staffing. The budget cuts make it almost impossible to hire the needed personnel, particularly when the Department of Justice is already tremendously understaffed. If the land court takes off, the IFP is worried that substandard work might become the order of the day because of the lack of staff, considering also that staff members at present are terribly overburdened. The IFP notes that the OCJ intended to keep vacancies in funded posts under 10%. However, with the budget cuts, it now seems unlikely that this will be possible. Will this not affect the right to access to courts and the right to have one's matter heard timeously? Further, will the budget cuts not result in the loss of employment for staff members to ensure that the OCJ remains within budget? The IFP worries that this critical office will be crippled by a lack of adequate funds, leading to the miscarriage of justice for many, as well as opening loopholes for corruption to take place. Thank you, Honorable House Chair. The IFP supports the budget.
Thank you very much, Honorable Msimang. We now invite the FF Plus, achtbare lid Mulder, FJ.
Dankie achtbare huisvoorsitter. Although the office of the Chief Justice is primarily established to support the Chief Justice and administration of superior courts, the Constitution's 17th Amendment Act designed or designated the Chief Justice as head of the judiciary with responsibility over the establishment and monitoring of norms and standards for the exercise of judicial functions of all courts. Chair, case backlogs in high courts is a big concern that poses a threat to our judicial system. The crisis has highlighted just how inefficient court processes are and the extreme need to modernize and digitize courts. Proposed budget cuts that will further affect the compensation of employees, budgets of all departments in particular, are likely to see the case backlogs increase even further. The committee noted that the lack of progress regarding the finalization of a court administration model that will see the transfer of functions presently still undertaken by the Department of Justice and Constitutional Development, such as security services at courts, due or to the office of the Chief Justice. The mere fact that the compensation of employees' budget will be seriously affected by the proposed budget reductions will mean, amongst others, that positions will not be filled. The reductions will not only contribute to further case backlogs, but will most certainly compromise the office of the Chief Justice's ability to provide support to the Chief Justice himself. The Freedom Front Plus welcomes the clean audit opinion, noting the Auditor General and Audit Committee's comments on the high standard of governance at the Office of the Chief Justice, but on the other hand, we note the human resources as being an area of weakness. House Chair, the fully fledged specialist court envisaged by the Land Court Bill with a judge president and more judges to adjudicate on land claims cases will be a recipe for disaster if it does not have enough resources at its disposal to support the Land Court. A preferred model should be finalized for judicial accountability on court performance. The planned transfer of more functions from the Department of Justice and the Constitutional Development to the Office of the Chief Justice and Court Administration should be put on hold till the office has been adequately equipped. House Chair, the Freedom Front Plus welcomes the fact that mention is made that Parliament has received a complaint from the Council for the advancement of Constitution relating to the conduct of members of Parliament representing Parliament at the Judicial Services Council, and whether such members can make comments that may be seen to undermine an independence of the judiciary. This unfortunate occurrence should be investigated. Achtbare huisvoorsitter, die Vryheidsfront Plus wil verder die hoofregter welkome en geseënde aftrede toewens en kan hierdie begroting nie ondersteun nie. Dankie huisvoorsitter.
Dankie achtbare lid. Ons gaan aan. Deputy Minister responsible for Justice and Constitutional Development. The Honorable Deputy Minister.
Honourable House Chairperson, Honourable Minister and Deputy Ministers, Honourable Members, members of the judiciary who may be watching on this virtual platform as well, friends. Our courts are often seen as the last bastion of people's rights and freedoms. Our courts act as the very buttress of a constitutional democracy. If our courts work, democracy works. If people have confidence in the judicial system, they have confidence in democracy. But our courts are not only a shield to protect people's rights and freedoms, they're also an embodiment of Lady Justice, who, blindfolded with sword and scales, has to fend off what is bad, has to protect human rights, bring about equality and fairness, and apply the law without fear, favor, or prejudice. As we celebrate the 25th anniversary of our 1996 Constitution, the independence of the judiciary and the institutional prominence of our courts lie at the very core of our constitutional dispensation. Our courts are there to serve the people and to ensure that justice is, as the famous saying goes, not only done, but manifestly seen to be done. At the very heart of our Constitution lies its transformative nature and the deep commitment to bring about change in our country. As former Chief Justice Pius Langa said, and I quote, "This is a magnificent goal for a constitution, to heal the wounds of the past and guide us to a better future. For me, this is the core idea of transformative constitutionalism that we must change," close quote. Our courts often are at the forefront of these changes. The Office of the Chief Justice was established as a government department, separate to the Department of Justice and Constitutional Development, to, amongst others, support the Chief Justice in executing his or her administrative and judicial powers and duties as head of the judiciary. In doing so, it assists with developing policy, norms and standards, and supporting the judicial function of the superior courts. It supports the Judicial Services Commission and the South African Judicial Education Institute in the execution of their mandates and administers the Judges' Remuneration and Conditions of Employment Act. The OCJ is responsible for running the superior courts, the high courts, the Supreme Court of Appeal, and the Constitutional Court, as well as specialized courts such as the labor courts. The OCJ further contributes to a capable, ethical, and developmental state by, amongst others, providing effective and efficient administrative support and improved court efficiency. Honourable Chairperson, if COVID-19 has taught us anything, it has taught us that we need to adapt and the justice system needs to be responsive to the needs of society. As the Minister has indicated, the Office of the Chief Justice has partially implemented the court online system in the Gauteng division of the High Court, with case lines being successfully piloted in these courts. The court online system provides a platform which allows for the electronic filing of documents. The OCJ aims to continue the rollout of this electronic platform during the medium-term strategic framework period. Our courts have to continue to function regardless of circumstances. They are essential services. They need to hear criminal matters so that remand detainees who are found not guilty can be released from custody. They need to deal with civil disputes, to issue protection orders, and to deal with urgent matters. COVID-19 has forced us to move faster into the electronic communications age. An excellent example of what can be achieved, albeit at a magistrate's court level, is a recent case in the Kimberley Children's Court. Initially, the matter was heard in the presence of all the parties in the courtroom, but due to many parties being involved and the costs involved, the presiding officer issued directives for the matter to be heard virtually. And the Department of Justice, because it was a magistrate's matter, immediately offered support and set up courtrooms with monitors, data connections, cameras, and so forth. The matter was conducted with the presiding chief magistrate, the legal aid practitioner, and the clerk of the court in the physical and transformed virtual courtroom. One attorney was with his clients in Benoni. One attorney was with his clients and their counsel in Katu, about 280 kilometers from Kimberley. And another attorney was with his clients in his offices in Kimberley. About 3 witnesses gave evidence from Bloemfontein, and then the parties in Katu and Benoni. We need to follow exemplary cases such as this. We have to simply do more things virtually. There is already a provision in the Criminal Procedure Act which allows witnesses to give evidence by way of electronic means. But these provisions in the Act come from a time when we didn't have virtual or online communication capabilities. So apart from the witness testifying rooms in sexual offences courts, this is rarely used. This must change. One can just imagine how much time and expense will be saved if a particular expert witness could give evidence remotely from their offices. It would save both time and money. The section which allows for electronic testimony is quite wide, so it would need to be experimented with and tried out in different scenarios to see if it works efficiently. And there's also currently no such provision for electronic evidence in civil and family law matters. Provision has been made for this in the COVID-19 court directions, but this only applies during the national state of disaster. It is being used by magistrates in civil, maintenance, and family law matters. We need to put this provision into our law permanently. For this purpose, we're currently preparing a Judicial Matters Amendment Bill to allow for a new chapter to be inserted in the Magistrates Court Act to provide for electronic proceedings in respect of civil matters. It aims to provide for an electronic proceedings management system and for filing, issuing, accessing, as well as the service, delivery, or discovery of documents by means of electronic communication services. It will allow for the conduct of court proceedings by means of electronic communication services. To further bring our courts fully into the digital age, the Rules Board for Courts of Law has considered that the benefits of technology should be utilized and incorporated into the civil justice system to improve the efficiency of our courts and enhance access to justice for users of the civil justice system. The Rules Board established a task team in 2018 to make recommendations on the amendment of the rules of the superior courts and the magistrates' courts to facilitate the use of electronic systems and to recommend new rules where necessary. The Rules Board has drafted its new e-rules proposal to regulate the processes relating to filing and service of pleadings and documents and the hearings of cases electronically. These new draft e-rules and amendments to the Uniform and Magistrate Court rules for the electronic civil justice system were recently published for public comment. These rules will bring about transformation from paper-based and face-to-face court procedures to an electronic system in civil cases. Legal practitioners will be registered as users of the e-justice system, and unrepresented litigants have the choice to register as users as well. It's important to highlight that unrepresented litigants who are not registered due to device, data, and/or skills constraints will be assisted by a service desk to scan and upload documents at service points at courts. Honourable members, the National Development Plan envisages a South Africa where people feel safe and enjoy a life free of crime. Achieving this requires a well-functioning criminal justice system. Yet all of us face the daily challenges of lengthy court processes, case backlogs, overcrowding in correctional facilities, and recidivism, which continue to confront the criminal justice system. There are many different role players and stakeholders in the criminal justice chain. They're all vital to ensure that our criminal courts function, be it the National Prosecuting Authority, legal practitioners, Legal Aid South Africa, court staff, court orderlies from the South African Police Service, the Department of Correctional Services, which house and transport detainees, and the Department of Social Development, which provides probation officers. There are judicial functions and administrative functions. The Constitution contains very specific roles for both the Chief Justice and the Minister of Justice, respectively. The Chief Justice is the head of the judiciary and exercises responsibility over the judicial functions of all courts. The cabinet member responsible for the administration of justice may, amongst others, appoint acting judges to other courts after consulting the senior judge of the court on which the acting judge will serve, and exercises final responsibility over the prosecuting authority. The Minister and Chief Justice have a shared role to play in court administration. We must highlight the importance of multi-stakeholder engagements to ensure that we have our courts functioning optimally. From the side of government, and specifically our department, we must strengthen and support our courts, and whether this means being the link between the judiciary and, for example, the Department of Public Works when it comes to a problem with infrastructure, or, for example, the interface between the judiciary and the South African Police Service We need to be the vehicle that ensures the judiciary and the courts get the support they need from other departments and institutions. The Chief Justice has set norms and standards for the exercise of all judicial functions in courts. With regard to court hours, we often see a discrepancy in court hours, with many courts not meeting the required 4.5 hours or 4.5 hours of sitting per day. These delays and or backlogs are caused by a number of factors. The OCJ recently presented a detailed breakdown of factors and causes leading to backlogs in the regional courts. In most cases, 12%, it was the accused person causing the delay. And another 12% was the prosecution. Private legal practitioners and Legal Aid South Africa were both stated as the cause in 11% of the cases, and witnesses non-availability 10%. What this means in short is we need to work together to ensure that the blockages in the system are unblocked. Chairperson, the medium-term strategic framework identifies the need to develop a unified approach between the three arms of the state to fast-track various outcomes. We're therefore preparing a social compact within the context of fostering and strengthening the constitutional relationship between the three branches of the state, namely the executive, legislature, and judiciary, underpinned by the doctrine of separation of powers, the independence of the judiciary, and the rule of law. The purpose and objective are to strengthen the working relationship of the three branches of state through the development of a social compact suited to the three branches so as to give effect to the National Development Plan's vision of building a capable, ethical, and developmental state. The medium-term strategic framework has identified the Department of Justice and Constitutional Development as the lead department, with the Presidency and the Department of Monitoring and Evaluation as contributing and supporting the process. It is envisaged that the discussion paper will be submitted to Cabinet for approval by the end of this year. Honourable members, COVID-19 has revealed one critical thing about our society. Efficiency in the justice system is non-negotiable. The only way to achieve this is to ensure maximum stakeholder cooperation. The users of our court deserve no less. Thank you.
Thank you, Honourable Deputy Minister. I now call upon Honourable Swartz of the SCDP. Honourable Swartz.
Thank you, House Chair. House Chair, the OCJ is allocated 2.33 billion in the present financial year, down by 144 million from last year. Now, we in the ACDP understand the need for the budget cuts, but share the Justice Committee's concerns about the one-size-fits-all approach adopted by National Treasury. Fiscal policy targets the reduction of the public sector wage bill, and this puts departments that are labor-intensive, such as the OCJ, in an extremely difficult position. The failure to adequately resource the judiciary can be regarded as undermining judicial independence. And it should also not be forgotten that the rule of law supports healthy, growing economies and should allow people to feel safe. Now, the OCJ raised a number of challenges it faces with the operation of the courts and access to justice. These due mainly to the impact of COVID-19 and the budgetary cuts. These challenges should be read with those mentioned by the Chief Justice as well in the Judiciary's annual report, which include the absence of full-blown court modernization, the absence of rulemaking authority, and the absence of the judiciary-led independent court administration. The committee's interaction directly with the judiciary was helpful and should be encouraged to find solutions to these issues. The ACDP shares concerns about the huge workload in our courts. This is reflected in an increased number of backlog cases as a result of courts having to limit matters being heard on account of COVID-19. The focus on addressing backlogs limits the ability to hear new matters, which creates a snowball effect. And with the fear, as expressed by previous speakers, is that case backlogs may eventually overwhelm the whole legal system. Chairperson, for the first time, virtual court hearings took place, with appeal courts faring well, but not so with trial courts, which constitute a major part of the court system. In this regard, the ACDP supports the Deputy Minister in is viewing and holding virtual trials, including at a magisterial level, and we look forward to the legislative and rule amendments in this regard. The ACDP is also pleased to see the judiciary at last dealing decisively with delinquency amongst its ranks. This week's decision by Deputy Chief Justice Raymond Zondo to Chair of the Judicial Conduct Committee to refer judges Sarita Muzi for charges of gross misconduct is to be welcome. Lastly, the ACDP would like to thank Chief Justice Mogoeng for his many years on the bench and wishes him well when he retires later this year. We also thank all those in the OCJ and the judiciary who, under very difficult conditions, have sought to ensure access to justice. I thank you.
Thank you very much. Can we call on UDM? UDM? Honorable Maseko Jele of the ANC, over to you.
Honorable Chairperson, members of the executive, members of the House, good afternoon. Indeed, this year, we mark the 20th anniversary of our much celebrated Constitution. Our Constitution is one of the most progressive in the world and enjoys acclaim internationally. The Constitution was adopted to, amongst others, heal the divisions of the past and give us a new and common identity. It is founded on human dignity, the achievement of equality, and the advancement of human rights and freedom. It is founded on a non-racial, non-sexism, and the supremacy of the Constitution. Constitutions and constitutionalism go hand in hand with human rights. Chapter 2 of our Constitution contains the Bill of Rights, which is the cornerstone of our democracy. It enshrines the rights of all people in South Africa and affirms the democratic values of human dignity, equality, and freedom. The Constitution additionally imposes a positive duty on the state of respect, protect, promote, and fulfill the rights in the Bill of Rights. Section 39 prescribes that everyone has the right to have any dispute that can be resolved by the application of law, decided by the third public hearing before the court. The Bill of Rights binds Parliament, the executive, judiciary, and all organs of the states. Chairperson, even before the advent of democracy, the African National Congress declared that the Bill of Rights will be enforced by the courts, headed by a newly created constitutional court, which would have the task of upholding the fundamental rights and freedom of all citizens against the state. Anybody or person seeking to deny those rights, we declare that the judiciary should be independent and would consist of men and women drawn from all sectors of the community on the basis of their integrity, skills, life experience, and wisdom. 25 years later, we have witnessed the Constitution being interpreted and enforced by our courts. We appreciate the progressive jurisprudence which has been developed by the courts, both in the lower and the superior courts. This contributes to our vibrant democracy. The mandate of the Office of the Chief Justice is to provide effective administrative and technical support to the Chief Justice as the head of the judiciary and the Constitutional Court. As it was mentioned, the OCJ was established as a measure to promote and reaffirm the principle of judicial independence as guaranteed by Section 165 of the Constitution. As aforementioned, Section 34 of the Constitution guarantees access to courts and other independent tribunal or forums. Unless ordinary people have access to courts and other independent forums or tribunals to resolve their disputes, the vision of a society based on the rule of law as envisaged by the Constitution will not be realized. The right to effective legal representation is an indispensable component of access to justice. It is an undeniable fact that legal services are inaccessible to most South Africans, particularly the poor and vulnerable groups in society. It is therefore this reason why Legal Aid South Africa exists, to protect human rights and promote justice in society. Chairperson, South Africa remains one of the most unequal societies in the world, with a highly skewed income distribution. The gap between the rich and poor widens and inequality deepens each year. Access to justice is constrained by the triple challenge of poverty, unemployment, and inequality. Even in our courts, which has increased the backlog of cases. We do not wish to see the legal system overwhelmed and the right to access to justice undermined. Justice delayed is justice denied. It is vital to ensure that courts have sufficient, even additional capacity in the form of warm bodies in order to efficiently deliver court services in line with the standards and the court's rules. Chairperson, it is often said that, I quote, every disaster is an opportunity, close quote. The new normal as a result of COVID-19 pandemic has created a push to the court modernization projects that were being piloted before the lockdown. The OCJ has continued to deliver services utilizing technology, mainly for conducting court hearings, conducting judicial education and training of officials, as well as convening meetings. It was reported that in 2020-2021, the intention is to continue along the trajectory, continuing to make use of court online system and improving the ICT infrastructure so that it can respond to business needs. The focus in 2021-2022, it will also be on modernizing the OCJ ICT network to cope with the increased demand for data transmission and implementation of court modernization systems. With the fourth industrial revolution upon us, the need for court online cannot be overstated. Chairperson, in the 52nd National Conference on the issues of transformation of the judiciary, the ANC resolved suit. Appropriate mechanisms must be urgently established to pursue judicial officers who are steeped in and deflect the institute, even during the COVID-19 pandemic. The training of magistrates in understand welcome that the of South African judicial key priority for the OCJ. Was I alone there?
Honorable member, thank you very much. I'm not sure if I'm audible. Can I now call on the AIC? AIC, PAC, PAC. Can I now call upon Honorable Horn of the DA?
Thank you, Chairperson.
Honorable Horn.
Thank you, Chairperson. Can you hear me? Thank you. 10 days ago, Chair, as others had alluded to, our Constitution turned 25 years of age. Now, Chair, the adoption of this Constitution was indeed a defining moment, a moment in which we as a country broke decisively with our past by adopting a supreme law which promised us that going forward, we would all be equal before the law. To ensure that our rights and freedoms as promised by the Bill of Rights were to be realized, we of course chose to entrust the judiciary with the all-important task of determining when called upon whether any exercise of public power is in breach of our Constitution or not. Now, Chair, to be successful in fulfilling this duty, it was always going to be vitally important that we be served by a judiciary which itself was to be subject only to the Constitution and the law, a truly independent judiciary as explicitly demanded by our Constitution. Chair, as others have pointed out, a number of additional measures were introduced over the years to support this independence. This department, the Office of the Chief Justice, was removed from the Department of Justice. In this regard, Chair, and in respect of this budget, it remains our serious concern that the budgetary allocation to the judiciary has also been adversely affected by the insane political choices of this government. The decision to persist with the continuous and repetitive bailouts of dysfunctional state-owned entities like SIA, even in the face of a fiscal cliff, has had a very real and very negative impact on the ability of the government to appropriate a suitable budget to the OCJ this year. The administration of the OCJ is to be commended for the way it looks after the funds entrusted to it, and the fact that it will not be able to optimally support the judiciary this year is it because of no fault of its own. Now, Chair, while this issue alone has the potential to undermine and erode the credibility and the independence of the judiciary, the time has also come to address the more serious ways in which the judiciary is being undermined at the moment. When our Constitution was adopted, and in order to break with our authoritarian past, a past in which the Minister of Justice had an unfettered authority to appoint judges, a Judicial Services Commission was established, tasked amongst other things with interviewing and nominating suitable candidates for appointment as judges. Now, the manner in which these interviews as of late, Chair, deteriorated is unacceptable in a country that professes to embrace equality and non-discrimination and who claims to have conclusively broken with our racially divisive and oppressive past. The question must be asked, how can we claim to be a country committed to never repeat the mistakes of our past if some members of the JSC attempt to and are allowed to target white and Indian applicants with questions aimed at illustrating that these candidates should not be considered for appointment merely because they are white or Indian. The same with candidates from a specific cultural and religious background. Now, Chair, a further measure to ensure the independence of the judiciary was the fact that it was entrusted, the JSC was entrusted with the enforcement of discipline amongst the judges of our high courts. Unfortunately, as has been pointed out by Honorable Breitenbach, this matter has not been dealt with successfully over the years. Now, Chair, history will judge the JSC very harshly for the failure to call for the suspension of Judge President Klope when he was first accused of serious misconduct. Similarly, history will not rule in favor of the JSC for deeming the matter not to be urgent or essential once this Judge President was finally found guilty after a hearing into which the JSC was forced by legal action from civil society. Add to this that the very same JSC then allowed for this Judge President to participate in interviews of prospective judges after having been found guilty and after being the tribunal having proposed that he be removed from office. And it should be abundantly clear to all of us that both common sense and the law was put on the altar by the JSC through its seeming reluctance to uphold the principles of legality and equality before the law when it came to one of its own. Now, Chair, in law, judges would be quick to point out that they always look for the so-called sine qua non moment or event, that one event without which all other consequential events could not and would not have occurred. By this measure, consider this: timely action by those who refused and failed to advise for the suspension of this Judge President more than a decade ago could have and probably would have prevented the unfolding of the further and more recent events that had plummeted the Western Cape High Court into chaos and brought it into a massive crisis. Chair, in the recent past, it has been noted, and rightfully so, that in some instances the judiciary has expressed its exasperation and disbelief at the way in which we as the legislature and even the executive, of which some members have joined us tonight has failed in our constitutional obligations. Therefore, in order to fulfill our role of oversight, let me say this very clearly. We hope, and yes, we even pray, that later this year, when a Chief Justice is to be selected an appointment, it would be a justice that will appreciate the importance of leading the JSC in such a manner and the judiciary that it not be accused that it asks of us a stronger obedience to the law and the Constitution than it demands of itself. I thank you.
Honorable Vote Draken of the ANC.
Chairperson and honorable members, as well as members of the judiciary present on the virtual platform, I greet all of you. Before I begin the speech, I would like to say that our committee and our study group have suffered a great loss with the passing of our comrade and whip, Honorable Member Jackie Mufokeng. Our deepest condolences to her family and her friends. We all meet during these difficult times. The COVID pandemic has forced us to work differently and to quickly move to working online. And various entities have had to make provision to work online as well. Many entities also face budget cuts and at the same time have to accommodate to working differently. Chairperson, the ANC supports the committee report on the budget of the Office of the Chief Justice for 2021-2022. The National Development Plan 2030 identifies, amongst others, the need to build safer communities, build a capable and developmental state, and strengthen judicial governance and rule of law. The OCJ contributes to all of these, and also the support it provides to the judiciary is intended to strengthen judicial governance and the rule of law by the following: accelerating reforms to implement judiciary-led court administration, ensuring an efficient court system, reducing inefficiencies in the administration of the courts, and ensuring access to justice. The establishment of the Office of the Chief Justice, with a mandate to provide administrative and technical support to the judicial branch of the state, was the fulfillment of a constitutional obligation and an important building block for our democracy. The OCJ Performance Plan for 2021-2022 financial year outlines the support it will provide to the judiciary in ensuring accountability, contributing in a very unique way to enhancing social cohesion throughout our justice system. The Chief Justice, as the head of the judiciary, exercises responsibility over the establishment and monitoring of norms and standards for the exercise of the judicial function of all the courts. The ANC declared in the 54th conference that the ANC should, as a matter of policy, pursue expropriation of land without compensation. This should be pursued without destabilizing the agricultural sector, without endangering food security in our country, and without undermining economic growth and job creation. The ANC's approach to land reform must be based on three elements: increased security of tenure, land restitution, and land redistribution. On the 10th of March, 2021, the Minister of Justice and Correctional Services signed a letter that was sent to the Speaker of Parliament, stating that Cabinet has approved the submission of the Land Court Bill to Parliament. This bill seeks to establish a specialized land court, with its judgments, orders, and decisions appealable at a specialist land court of appeal. The Portfolio Committee notes that the establishment of the Land Court will require additional resources, including provision for the appointment of permanent judges and support staff. The committee also trusts that the OCJ will not be required to find funds for the implementation of the court from its already stretched baseline, and understand that the OCJ is engaging National Treasury on this. However, the committee will engage further on the resourcing of the court when considering the draft Land Court Bill. To assist in the fight against gender-based violence and femicide, the Department of Justice and Correctional Services, aligned with SONA 2021, will designate 99 additional courts as sexual offences courts, and it will increase the number of Thuthuzela care centres from 58 to 61 by 2023-2024. I'm happy to say that as part of my constituency work and to find out what the South African police services are doing about gender-based violence and to check on their victim support room, Yesterday, I had the opportunity to visit and talk with SAPS in Maritzburg in the Western Cape. This included a visit to a newly launched safe house, which forms part of the TCC rollout. And I would like to commend that process. The 2019-2020 Judiciary Report repeats the Judiciary's proposal for the adoption of some of the measures that could help alleviate the plight of victims of gender-based violence and strengthen the fight against the scourge even more. The focus is on public awareness campaigns by people who are knowledgeable in responding to and reporting these offences, revitalizing capacitation and establishment of more Tutuzela care centers, the establishment of focused, appropriately sensitized and well-trained units of investigators and similarly equipped pool of prosecutors to deal primarily or exclusively with sexual offenses and gender-based violence cases. Judicial officers must be especially trained on the investigation and further handling of these cases. And sexual offences courts must in reality be endowed with a critical capacity or resources. The Office of the Chief Justice has a budget of 2.33 billion rands. And one of the MTF focus areas will be to improve access. The ANC supports an independent judiciary. Parliament plays an oversight role in considering matters of the magistracy and an active role in the appointment of judges. Section 178 of the Constitution provides for the composition of the Judicial Services Commission, the JSC. The JSC selects fit and proper persons for the appointment as judges and to investigate complaints about judicial officers. It also advises government on any matter relating to the judiciary or to the administration of the JSC or to the administration. And the JSC includes members of parliament from both houses of parliament, the National Assembly and the National Council of Provinces. The Magistrate Act provides for the composition of the Magistrates Commission. 4 members of the National Assembly and 4 members of the NCOP are included in the Magistrate Commission. Honourable Chairperson, while I still have time, may I please make a plea to the Office of the Chief Justice. In my engagement with SAPS yesterday, something came up regarding language, and I would like for the Office of the Chief Justice to look into this issue. I'll give you an example. When a victim comes to a police station, they express themselves in their own language, but the officers have to write the statement, take the statement in English. This traumatizes the victim even more when the report is read back in English or in not the language of the victim. And this also puts pressure, additional pressure on the victim. The SAPS has informed me that they are compelled to write the report in English because the report goes to the court and court officials may want the report in English. My appeal is that the court provides more translation facilities and for court officials to not be burdened with having to do the translation. The victim should have a right to express themselves in their own language. I thank you, Chair.
Thank you very much. I now call upon the Minister to take over. Honorable Minister. Honorable Minister.
Thank you, Honorable Chairperson. I will respond without the video if you allow me, due to the light here. Yeah, thank you. Firstly, is to thank the members, the honorable members, for their contribution on the matter. And indeed, the issue of the budget cuts is a concern for all of us and throughout the whole of government. And as I said earlier, that it's something that we have to live with given the current fiscal environment. But I do get the comments by members that it may affect the operations of the courts and to a certain extent affect the issues that relates to the rule of law. We will continue to engage with the National Treasury to impress on this matter, given its importance. With regards to the shopper matter is in front of the Judicial Conduct Authority and the Judicial Service Commission. It will deliberate on the matter on the 4th of June. I will prefer that I leave it there for the deliberations of that structure, because honorable members will also appreciate that as also a member sitting in that platform, I am also gonna have my views that I will have to express in that platform. So it will be inappropriate for me to comment and express a view with regards to that outcome at this stage. I will request that I be allowed, the chair, to express the views in that platform when the report is tabled. And I think in the next sittings, maybe the House will also have an opportunity to deliberate on the matter. But I also take note of the fact that the matter will also be processed through Parliament, that relates to the members of Parliament who sit in the Judicial Service Commission. There is no executive or anyone who is attempting to capture the judiciary. We continue to give support to the judiciary and understand that it's independent and that that independence is sacrosanct. The issues relating to the sealing of documents are currently being ventilated in our courts. And I think the checks and balances of the courts will be able to determine whether the decision to seal those documents was in line with was lawful or not lawful. And the courts will express their opinions and views in that regard. And that is the beauty of our court system. It has got its own built checks and balances that enables no one to manipulate, to circumvent, or to even suppress the role of the courts in our constitutional democracy. There is no one who can be able to do that. And we can state here, Honorable Chair, that we continue to give support and also call for South Africans to protect and defend the judiciary in the execution of its responsibility, that of safeguarding the constitution of our country. And any unfounded theories, conspiracies must be condemned in a constitutional democracy. And any criticism should be fair, balanced, and be informed by the facts and the law that is directed to the judiciary. With regards to the issues raised about the lower courts, indeed, Chair, there are challenges which we continue to work on through the courts presidents, the regional courts presidents, and the deputy minister, to resolve some of the issues that relate to the backlogs that also affect some of our inmates who sometimes stay long before the trials and so forth. There is that process that is underway. The issues raised again relates to, most of the honorable members raised issues related to the cutting of the budget, which I've already commented on, including the staffing. With regards to the land court bill, we share the sentiments of the honorable members with regards to to it going to affect the staffing and also the budget of the office of the OCJ. Hence, there's that continuous discussion with the National Treasury to see how do we help to resource this process, because the land court will play a very critical role if we are able to fill the vacancies in that court and have full-time judges in speeding up matters related to the land question, which is a priority matter for our country, which is also important for social cohesion and the economy, that there is stability and jurisprudential clarity with regards to matters related to the land. So the land court will play that important role to bring certainty and clarity on these matters. Hence, it's a very important court in our young democracy. The issues related to the virtual trials, the Deputy Minister has commented on, and I agree with him, and including some of the members, which include Honorable Swart, and the matters that have been raised about the 25 years of democracy. I agree that we have a role to play in ensuring that the Constitution is also entrenched across the country, and we continue to play a role to defend and protect and even promote and deepen constitutional democracy. With these words, Honorable Chairperson, I want to thank all the members for their participation and their insightful comments, which we are going to take into heart and also into our minds to continue to improve the service to the people of South Africa. Thank you very much.
Thank you very much, Honorable Minister. That concludes the debate and the business of the mini plenary. The session is adjourned. Thank you very much.